Just hold. Yeah. Good evening, everyone. And as we all, as a student of law, have seen that the arbitration has picked up, and they say that this is one of the subjects which has picked up, and all lawyers, judges, and persons associated have started feeling that this is a via media which helps to facilitate the justice delivery system and dispensation system in a better perspective and manner. We did a session with Justice Dhanuka last week, wherein he spoke about the overview of the Arbitration Act. We had done earlier one session with Justice Dhanuka and Justice Dalvi on the arbitration. So I think both work in a tandem whenever the Arbitration Act comes. So when he gave the overview at a discussion with Justice Roshan Dalvi, she said there are a lot of anomalies which are actually to be required to be creased out. As in law, they say that when they have wrinkles, the only way is to iron them out. And today we will be discussing and traversing through that through Justice Roshan Dalvi. With respect to the anomalies, we are quite sure that those who are listening to it will actually see that the points are well taken and they can actually help to resolve those anomalies. And thank you, ma'am, for always coming, sharing your knowledge, enlightening not only Beyond Law CLC, but all those viewers who are watching that. Over to you, ma'am.
Thank you. Good evening, Vikas, and good evening, friends. Since we had a very exhaustive lecture last week by Justice R.D. Dhanuka, who actually took us through the entire book. If it was the school, he would have got 100 marks on 100. And I thought, when I was speaking to Vikas, that yes, in practice, though the law is so streamlined now, there are several anomalies which arise either because of, you can say, use, misuse, abuse, or misunderstanding of the provisions. Now, this causes a little complication in some of the aspects and a little more in some others. So, though I will not take you exactly through each of the sections from section 1, I will take you through the sections itself, just as Justice Dhanuka did, for those sections where anomalies exist. We begin with the much used sections 9 and 17. Now, what happens is, we must first understand the history of the litigation and the history of the arbitration. In the good old days, and friends, I'm not talking about prehistoric times, I am talking about just when I was practicing or a little before. And I've been now in the profession for 48 years. So you can say about 50 years ago, there used to be suits in Mumbai, that is in the Bombay City Civil Court and the Bombay High Court, which reached hearing in about 6 months, 8 months, 1 year, something like that. At that time, there used to be interim reliefs and interim applications. Now, these are called notice of motion in Mumbai. They may be called by different names in different jurisdictions, like Exhibit F or interim application only or whatever. What happened was that essentially it used to be that you tell the defendant to hold his horses. And the court saw that the suit is filed, there is a prima facie case, wait it out now. We'll just take up your suit, file your written statement and come back and we'll begin with the suit. In this scenario, the interim reliefs took not even 5 minutes. Even when I started practice and through the first decade of my practice, interim relief applications were few and far between. When new suits were filed, which was not like today in hundreds every day, and the judge who took up the notice of motion board was one only to take up interim applications. And at the end of the day, when about half an hour was remaining, he would then take up ad interim applications, which is to say, please hold your horses until I hear your interim application. And even when interim applications were taken out, it used to be on orders without reasons because they were interim. I remember fine judges like Justice Bharucha, Justice Manohar, who heard and immediately said that okay, there'll be reliefs in terms of prayers A and B, or only A, or only B, which were generally injunction and appointment of court receiver. And I remember also that Justice Bharucha's associate may be very smart, and therefore he only said sometimes A. Sometimes he said A and B, or sometimes B. That's it. Nobody took these matters in appeal because matters were coming up for hearing. And when they came up for hearing, it would be just once and for all a suit reached hearing, so that then you read the pleadings, frame the issues, record the admissions, take the documents, and start the evidence. At that time, it was only oral evidence in any civil suit. There was no appointment of commissioners under Order 18. There was no recording of cross-examinations by somebody else. There was no affidavits of evidence. It began, and as soon as the affidavit of, and as soon as the oral evidence, that is the oral examination in chief, got over, the next minute the cross-examination began, and another witness, and both parties closed their case, and then arguments on the next day. It was as perfect, as smoothened as that. Now, even in arbitrations at that time, there were interim reliefs, and they used to be granted that way. But down across the road, somewhere like in the rest of many of the other things, the fine system got degraded. And then we had interim applications after interim applications, ad interim applications, and then even in arbitrations, there were interim applications. In a very, very well drafted legislation like the amendment of 2015 of the Arbitration Act, I don't want to go into the earlier act and the later act. It was 1940, as you all know, and then the new act of 1996, which also failed to deliver. And then we had the amendments of 2015, and claims could be filed even after an interim application could be moved. So interim applications under the act were moved before the court, not before the arbitrator. There was no claim at that time, and on some documents, parties would argue. Perhaps this is the only lapse or lack in the new Arbitration Act, I would say, of 2015, where this is the only proceeding where without the main proceeding, the interim relief application is made. Okay. Now, there were two provisions, Section 9 in the court, Section 17 before the arbitrator. Therefore, there are several matters where the court says, okay, now you made this application, file your claim, and go before the arbitrator. So now we as arbitrators decide those. Unfortunately, because there is no claim, it results in a lot of anomaly. And I, for one, insist that just as you would make a note or you make an application, you file your claim so that we understand the ambit and the periphery of what we are going to decide and see the prima facie case. So I give you relief immediately. And that I do. Now, this applies equally to Section 17. When we are hearing interim applications, therefore, when the final hearing could be heard becomes very material. Because if parties feel and know that final hearing is not going to come up quickly, they will prolong the interim application because they will really want the relief before the final hearing and then go on and on with the actual arbitration before the final hearing reaches. So, friends, the anomaly is this: short interim applications, quick reliefs, go straight to the final hearing, and the whole system gets smoothened. Okay. Now the appointment of arbitrators. Of course, parties can appoint whoever they want, one or three. And if they don't agree, then they come to court. So under section 11, the court appoints. When the court appoints, the court will see whether it is an arbitrable dispute. There was a lot of anomaly about stamping in the last year, in 2023. Some courts held that even if the agreement is not stamped, where the arbitration clause is, it doesn't matter. You have to start with the arbitration because the spirit of the Arbitration Act is to move fast, speedily, with less cost, and with great speed. But some courts held that no, stamp duty will have to be paid, and it cannot be paid after the arbitration gets to be in progress. Therefore, if a person relies on an agreement which is not stamped but which is required to be stamped or which is inadequately stamped, he must first go and get it adjudicated, and then only there can be arbitrability. Then there came a judgment which said, oh, arbitrability can be considered, but the arbitral tribunal will decide about what to do with this Stamp Act initially. So the arbitrators would then say that we will hold our horses. You've not paid the stamp duty. Go adjudicate and come back. Again, there will be an anomaly because a party may go to adjudicate for some reason or the other. Because of misfortune or misconduct of somebody, the adjudication may not take place for years. A party may not want to progress and proceed with the arbitration and may just file it and delay, as so many times suits and applications are filed, petitions are filed and delayed. Sometimes the other party may see to it that the adjudication is not made so that that claim gets delayed. Therefore, much remains upon the arbitrator to take an active part, an activist role to see once the party applies for adjudication that the party would get the matter adjudicated, and therefore some kind of directions, some kind of requests, etc., would have to be made by the arbitrator, and the arbitration should not be adjourned as we call sine die or any such thing. That is the arbitrator's duty. Now, after appointment comes the question of who will appoint, the High Court or the Supreme Court, as we know. In the amendment of 2019, it will be the arbitral tribunal. Once the arbitral tribunal is established, who will appoint? There will be a chairman and two members. The members would be a High Court judge. The chairman would be, I suppose, a Chief Justice or a judge of the Supreme Court, and another member. And they would be in charge of appointment throughout the country. Now, this would have also been a very good thing, but from 2019, when the amendments came, it has not been brought into force, and we are now in 2024. So section 3 capital A of section 11, subsection 3 capital A of section 11 is not yet in force. Now, after appointment of arbitral tribunal, the provision under subsection 14 is for the fees. The fees would be as determined by the statute. The statute lays down ad valorem fees. Just as you pay court fees, you pay arbitration fee. I think there should be nothing wrong with that. And this fee has to be charged by whoever accepts the arbitration. That is, whichever arbitrator accepts the arbitration, where he is or she is appointed by the court. There are only two exceptions. One is for international commercial arbitration, and the other is for appointment by an arbitral institution, which has got its own rules, where you follow those rules. Most of the rules of most of the arbitral institutions are more or less like the fourth schedule under section 1114, and therefore in terms 99% of the arbitrations would be governed that way. Now there is a dichotomy of interpretation where arbitrators are appointed by parties and not by the court. There have been arbitrations where we follow and abide the law. As I see it, my interpretation is that each one must abide that law. But there is another interpretation that if parties agree, then of course you can pay those fees. And therefore, even under the Arbitration Act, there is a provision. And so for payment of fees also, whatever the parties agree can be paid. And that must be then the matter between the arbitrator and the parties. Now, friends, the place of arbitration under Section 20. Any place appropriate to the actual dispute. The parties would decide on the jurisdiction of the courts. If there are two courts that have jurisdiction, they decide on one of them. The parties for arbitration can even decide on an arbitral tribunal outside both of the jurisdictions. That is, say, parties from India and Pakistan may decide to go to London. Now, this is the place of arbitration, but there is also the locus of arbitration. All this, friends, have been whittled down much after COVID, or rather from COVID times, because we have started online arbitrations. And though the place or the seat of arbitration is one, online you can meet anywhere. It's a very, very fine thing that has come into being. It saves costs, it saves time and energy. It allows advocates to appear in multiple matters in a given day, at least a couple of them. And it also is very feasible for arbitrations. So, though online is only a matter of practice and not in our laws, it is a practice which is now well settled. Most of my arbitrations are only online, entirely. And I'll come step by step as to how we do that. Now, under Section 23, the claim, the SOD, the counterclaim, and the reply to the counterclaim. These are the four, as we call, pleadings. Now, there is a 6-month period given under the 2019 Act, which makes an amendment to the 2015 amendment for calculation of the first 6 months of arbitration after the date of reference. That is also now well settled. And though that is what I would say, whittling down of the 2015 amendment, which was very fine, and which at least I felt could be absolutely adhered to in most of the matters, this is now in place. It must, this 4 things must be done within this 6-month period. And after the last of the pleadings is filed, is the 12-month period under Section 29A to be computed. We'll come to Section 29A a little later when I'll make a reference to this also. At present, we leave it at that, except that the anomaly arises like this. In some matters, there is a claim and an SOD. So it's very simple. From the date of the SOD, 12 months, and SOD within 6 months. And that is from the date of reference. But in some matters, there is a counterclaim along with the SOD or even after the SOD. And then there is a reply to the counterclaim. Even then, as finally interpreted under Section 23, all this has to be finished within 6 months. Okay. Now, what happens if it is not finished? There are matters where either the defendant refuses to file the defense or the respondent refuses to file the SOD or written statement in time, applies for time all along, and the claimant says it's okay, let him get the written statement so that we don't want to go to court, get some order, get some directions, get the arbitration frustrated and then restart again and all that, and let us continue. It would be for the interpretation of the courts to say whether this kind of consent, which is not allowed otherwise in law, it is not subject to a contract to the contrary. It is that this kind of time limit has been fixed. Why is this time limit fixed? It is, see, every law, just like every government that we get is what we deserve. The laws also that we get are what we deserve. Prior to 2015, there used to be years delays. The claim is not filed, interim application is moved, interim relief is granted, the claimant doesn't come back again for a long time. After the claim is filed, the written statement doesn't come, they go on applying for time. And therefore, there is this kind of a carrot and stick policy. This is the stick. 6 months is the utmost time. And friends, in other jurisdictions, and we would talk about jurisdictions which do much better than we do, let us say in New York, in London, in Singapore, it doesn't even take 6 months. The entire arbitration gets finished well before 6 months. So this is a very, very reasonable period. At present, for this 6 months, we stop at that. We'll come back to this when we deal with section 29A and why it came about. Now, friends, we go to section 24. The arbitrator, unless the parties have agreed, will decide on the procedure. The procedure has to be flexible. Whether or not there will be oral evidence, whether or not there will be only documents to be considered, is for the arbitrator along with the advocates of all the parties to decide. There are many matters where one party says, I'll not lead any evidence, and you can just take the claim or you can just take my defense. There are several matters where both parties also do that. And then it becomes very, very smooth because ultimately it is a commercial contract. It has to be interpreted. And after the commercial contract, there is invariably correspondence between the parties. Earlier, it used to be by way of letters. Now it is by way of emails. And this is a chain of correspondence, so everything can be taken together. And not much else remains. If there are certain things that remain because you are relying upon other documents of somebody else, then the author only can give direct oral evidence to prove those documents, and that much oral evidence would be required. So then what happens is, how do you compute, or rather, how do you allow these pleadings to be considered in the evidence when parties say we want to lead evidence? One of the things to curtail unnecessary oral evidence is to say that both the pleadings of both of you will be treated as your evidence. Okay? So, examination in chief or the affidavit of evidence, which is quite often a repetition of the claim and the defense, need not be filed. No time need be wasted to be filed, and no time need be wasted to read it up. Only that portion of the evidence of the pleadings which require proof by oral evidence, that much can be led by the parties, or you can go direct to the other witnesses who would have to give direct oral evidence to prove their documents of which they are authors. Now that done under section 24, we decide whether it is oral evidence, whether it is oral arguments, whether it is only on documents, and the arbitration can proceed. But quite often, parties request for oral hearing. Much later is it realized that that oral hearing was either counterproductive or completely irrelevant. But be that as it may, that must be allowed, and that is allowed under the Act as well as under the practice. The only result is that because he wants to lead oral evidence, I'll want to read oral evidence, and therefore that oral evidence becomes unnecessary, ultimately. Now there is a proviso. Proviso to section 24 is that if you want to lead oral evidence, and if that is allowed, then it must go on day to day. That day-to-day business has not been followed for the last at least 30 years. As I told you the history of litigation, earlier it used to be actually day-to-day. 4 witnesses over a period of 14 days from Monday to Friday, Monday to Friday. That way, But it is no longer like that. Costs can be granted, even exemplary and compensatory costs, but quite often it's not granted. We allow, and this allowance is what we tolerate. And whatever is tolerated is done, whatever is not tolerated is not done. And there must be a time that all arbitrators, as the captains of arbitration, must know how to put their foot down. That remains to be seen. Now, friends, under section 25(3), 25 is that if the claimant doesn't come, dismiss it. If the respondent doesn't come, grant ex parte decree, where there is no anomaly in that. But in 23, when a party fails to appear or produce its oral evidence or its witnesses, how long can or must an arbitration wait? We wait far too long in any case. There are times when the arbitrators must call it a day, and that is what creates the anomaly. Do we continue or do we not? So, when the party fails to appear, the law says the arbitrator will continue and finish up the arbitration and grant the award based upon the evidence which is produced. Now, therefore, suppose no evidence is produced, no oral evidence is produced, though demanded or requested. The pleadings are always there. The commercial document would always have the commercial agreement and the correspondence. And most of the things could be settled in the award under that. Okay, so that can be considered. Then another provision which causes a lot of interesting anomaly is section 26. Section 26 is the appointment of experts. We did not have in our CPC a provision for appointment of experts which could be used in every alternate matter. But since this is a complete code and it is a very small code, and section 26 says appointment of expert, there are several matters where parties want to appoint needless experts, whom they call experts. Now, what we have to consider is who would be this expert? The section as it goes says if the arbitrator feels that it requires some expert knowledge, some expert opinion, then it has she or he will have freedom to call for anyone. Generally, it is an auditor. Now, how would the auditor be an expert if the party wants to appoint an auditor? The question number one would be, you are having some accounts. You are in all probability a company, limited or private limited. Have you audited your accounts? The answer, no. The question is, if you have not audited, why should I get your accounts audited? I may not want it audited. If the answer is yes, I have got it audited. Okay, produce your auditor's report and produce your auditor for cross-examination. I'll take the auditor's report. So an auditor is not a person who need be appointed upon an application of any party. However, if parties have had an auditor's report, if both parties are producing auditor's report, which may happen sometimes in rare cases, then the arbitrator may feel that I want an auditor of my confidence, or I want an auditor who is independent, and that auditor is the expert auditor actually. So when the arbitrator decides, and it may be even after the entire evidence is led, after arguments are heard also, the arbitrator may say that I have heard your arguments, but I need expert opinion. And at that stage also, as I interpret it, the expert can be appointed, but not on the request or demand of any party as such. The next best experts, I would say, are architects, RCC consultants, etc. There are matters of construction. There are matters where we have to see plans. We all know how to read plans. The lawyers know and the arbitrators know. But somebody may feel that the plan could not be read correctly and we want to understand. Again, the arbitrator may get the expert evidence, but a party cannot say that I think that you need an expert. Therefore, you appoint an expert. The section as it runs is for the facilitation of the arbitrator. So that anomaly may be settled sometimes by a judgment. Then comes section 27, court assistance. Now there are parties who would lead evidence. They would lead evidence of other witnesses. Let us say, for example, an architect and an RCC consultant. No bar, no question. In fact, it's always welcome, so that we understand from an independent expert's view, an independent professional's view, what and how to interpret the documents, or what has happened in the construction or any such thing. But when the party says that you obtain court evidence, I am not going to be able to get the witness, or I am not going to get the witness. Well, sorry, there is an anomaly, it cannot be allowed. It should be just as in adjudication that parties must first procure their witnesses. If the witnesses don't come just upon mere calling, then you have to get the summons issued, if not, get the warrant issued. So similarly, here also the parties must exert to get their witnesses, whoever they be, and they are always welcome. No arbitrator will say, I don't want to record this evidence. It is only later that we say whether that evidence was really material or not. But we allow. Okay? So, if you require somebody to serve a summons, it would mean that you have exerted enough to procure his evidence. You've written to him, you've told him orally, whatever way, and he has refused to come. And then you say, okay, 1, 2, 3. These are the witnesses who have refused to come. 1, 2, 3. I'm going to examine myself. So then the arbitrator will give permission for the party to go to court and get the assistance of the court, which would be by execution of a witness summons. And then, of course, the witness must come, and if he doesn't come, it is contemptuous, etc., which is laid down in the Act. Now, friends, we go to Section 29A. Section 29A, generally we call a carrot and stick policy, but I would say it is a carrot and whip policy. And again, we must understand the history and why has it come, because as we say, we get the laws we deserve. This came in 2015. What was the position prior to 2015? In the 1996 Act, arbitrations would take any number of years from say 5 to 15, and that was deplorable. That's quite a national shame, I would say. And the law came down that we are laying down some reasonable limit. Under subsection 1, 12 months. Under subsection 2, it may become even 6 months. And if the arbitrator finishes within 6 months, you may give more fees to the arbitrator. I have finished within 6 months from the date of reference. I have not got more fees. I have not charged more fees. I have not asked for more fees. But the arbitration got over. Not all, but some. And then under subsection 3, you can't finish within 12-month period. So you get 6 more months by consent of the parties. Now, here is where it becomes very anomalous. The arbitrator may be the cause, or one or both of the parties or their lawyers may be the cause. That distinction has to be made. Being an arbitrator and not being such a cause, I say that with great responsibility, that the section proceeds on a footing that arbitrator has delayed. Yes, there are several arbitrators who delay, but no, all arbitrators do not delay. I do not delay, and I know of others who do not delay. Now, what happens to those arbitrators? That is an anomalous position. So when the parties say, all right, we have not finished within 12 months, so we will get another 6 months, we have agreed. Okay, you both agree, but the arbitrator may not agree. The arbitrator has worked diligently for 12 months. The arbitrator has given dates as soon as you want, given 2-3 days here and there. The arbitrator has always come and not delayed. Then what happens? What about the arbitrator's fees? Now, with this, friends, we go to that 4th schedule. When arbitrators are appointed, except under international commercial arbitration or in an arbitral institution, which is dealt with separately as exceptions, when the court appoints, when the parties appoint, the arbitrators must take ad valorem fee under the 4th schedule. That is the law. How they interpret it otherwise is not my concern. That is not an anomaly. That may be an interpretation or a wrong interpretation. But otherwise, as interpreted, that is the law. Now, we read a statute as a whole. So when we have got a time period under section 29A and we have got fixed fees under the fourth schedule, we have to read both of them together. The court says finish within 12 months. We say yes, and we take it up. And we want to work. And the parties may not work, one of the parties may not work. There may be several acts of dismissal, there may be several acts of actual delay. Whatever that happens, it depends on the facts of each case. The arbitrator says, I'm not concerned. I want more fees now because my fees must be paid. So much for 12 months. For 6 months, I may charge more, or quite often we do not charge more, but we get our fees paid. Then comes the extension under section 4. Even after 18 months, it's not finished. And quite often, it is not because of the arbitrator. Sometimes it may be because of the arbitrator. Sometimes, and more often, it is because of parties or one of the parties or lawyers or one of the lawyers. Then what happens? They go to the court. The court extends. The court may extend for 2 months, 3 months, 6 months, 1 year, whatever, depending upon the facts of each case. The court may even substitute an arbitrator, and the court may reduce the fees of arbitrator, and the court will give sufficient cause. The court will extend and upon its own terms. Now consider, friends, the anomalous position of substitution and or reduction of fee. What happens to an arbitrator who does not deserve that, but deserves quite the other things? Then that provision is not made under section 29A and therefore would be in the discretion of the court or in the discretion of the arbitrator. Now, this is a statutory provision up to 12 months and let us say for another 6 months, because it goes on in the same arbitration between the arbitrator and the lawyers. But later on, and even for the 6-month extension at times, it is a contractual obligation. It is a contract between the parties. The parties may consent. The arbitrator may not consent. The arbitrator may say, I've done my job. I don't want to take an extension. Can the arbitrator not say this? Of course, only if the arbitrator can show that this is the work that he has done or she has done. And what happens to addition of the fees if the arbitrator has acted diligently, as quite a few of us do, and there is no provision for that. But if you go for an extension of the period, it must be accompanied by what must be the extension of the fee, which today remains with the arbitrator to take up or not to take up, and for the court to grant or refuse reduction or addition. That is in section 29A. Then, of course, section 29B, not oft used, but it is a fast-track procedure. When there are matters of companies, and I've seen matters of companies in mergers, amalgamations, takeovers, where there are third parties involved, where there are various claims of, say, laborers, of contractors, of shareholders, etc., to be considered, then parties do not want reasons for the award or anything, but they want an award. They may not be able to settle their disputes, which generally gets settled. And they come up with their petitions for amalgamation and arrangement and takeovers and mergers. But otherwise, it falls for arbitration, and those are fast-track arbitrations, where again, there is no provision for fees that could be demanded otherwise than under the fourth schedule. It may be that parties agree to pay less or to pay more, depending upon the work that is given to the arbitrator, and subject to that, the fourth schedule can and must apply. Then comes section 30 for settlements. Now, this settlement, for example, friends, would be what we call mid-arb. The arbitration has to be dealt with And once the arbitration is being dealt with, the arbitrator may feel that these are parties in business relationships or in family relationships or in family businesses where the relationship must be maintained even after this dispute gets over. And that would be in the interest of both the parties. Therefore, Section 30 says settlement, and the Act is Arbitration and Conciliation Act. So the rest of the provisions, which I'm not going to deal with today, of course, are of a conciliation. And how a conciliator is appointed and what he does and how the proceedings are confidential and they are bound and the parties are bound by them. But failing that, at least a settlement can be sort of brokered by the arbitrator. Now, an ideal way of doing it is to first evaluate the arbitration because then you would know the merits of the case. By reading the pleadings, by and large, we understand the merits of the case. But after reading all the documents with the pleadings and the oral evidence that comes, we would be in a better position to still understand because we may be able to change our minds. And then comes the actual evaluation, which we do otherwise in an award. By giving the reasons, we evaluate the evidence, we appreciate the evidence. But when we have to do this settlement, there are two modes otherwise. We don't have mediation under this act. Now we have got the mediation under a separate act. Much later, 2023, but we have now got it. Now there are some clauses in agreements which say that if there is a dispute, all the disputes will be referred to arbitration. When we were dealing with mediations, when we were propagating mediations, when we dealt with it in various courts, we said, why not have agreements that first you go to mediation, then you go to arbitration, the mediator himself becomes an arbitrator and gives an award if both parties cannot and do not settle. This is what happens in many other democracies and it has worked very well. This is only if that same mediator would continue as the arbitrator. But that is not our system as yet. Parties don't say, we are appointing you mediator first, please mediate, see whether we can settle, help us to settle, create options for settlement. And if not, give an award. That doesn't happen. So what we do is, we get the reference for the arbitration. Our duty is to arbitrate. Okay? The parties have decided that they will go for arbitration. So they want us to arbitrate. Now, when this arbitration goes on and the evaluation is made, the arbitrator might understand quite often, yes, but it is ideal then to give an award, to keep an award ready. If the award is kept ready and yet the arbitrator can go a little outside his duties or her duties to say, I'll do a little more, I think it will be much better for you to settle this dispute because you'll maintain business relations. You'll come back to the same advocates afterwards if there is any other dispute because there will be so many other contracts or in family you will be able to come together. I could mediate. I would mediate without additional fee. I would mediate for a particular amount of time. And that may create a seed for settlement. Now, if that is not done, then of course it cannot go on endlessly. The award must be kept ready and it can be served if the parties have not agreed. The seed having been sown, the parties will think about it later because we have had this kind of an creation of options meeting. It is a confidential meeting. Such and such a thing has come out of the meeting. I can't do anything about it when I challenge the award or when I enforce the award. So one party goes to enforce the award, one party goes to challenge the award, and the parties may rethink and come together. This is what happens in a few matters that I have been told about. And I have done this. It is mediation. So we can have this conciliation proceeding where an arbitrator can create an option and then the parties would say, okay, we abide by it. Okay. So this is reading everything together. The oral evidence, rather the documents, the evidence, appreciation of evidence, giving of the award, and then trying to settle. Now, the question of settlement, the section of settlement comes a little before the section of the award. So I may tell you under section 31, again, award. Very simple. There's no anomaly. All arbitrators take their stamp papers, signed, put the date, put the place of arbitration, give the reasons, pass the award. The subsection 6 of section 31 says interim award. Not many interim awards are passed. Quite often at the time of the award, if you think that an interim award could have been passed, it means that it is skipped. If there is a kind of an admission, any kind of admission anywhere of some amount of money or some amount of work to be done, that much could be an interim award immediately. So that the remainder of the dispute then goes to arbitration and is arbitrated. Even when there are two separate and distinct aspects of an arbitration. One is whether there was, let us say, by consent, some kind of a final settlement. We call it an NOC in most of the commercial contracts, that an NOC is given by one party. The party says, no, it was under economic duress. It was that I had to get the money, and the other party said, I'll not pay you this much money if you don't say it is in full and final settlement. So he gives the NOC. Now that NOC has to be adjudicated, correct? So it has to be arbitrated, and we have to decide whether this NOC was given with or without duress. Suppose you find that the NOC is not given with duress because all that the work that was done has been paid for. Then there is no question of duress. All that the two parties would say, but the other party would say is, please, you have not completed the contract. Please go out. I am prepared to pay you for whatever work you have done. That is not duress. But if more is going to be given, more is kind of payable and is not paid, there may be duress. And therefore, oral evidence would be required to see how this particular NOC, as we call it, that particular letter or agreement came to be executed, what happened. Once that is done, an interim award on that can be passed, especially if the arbitrator holds that NOC was correct. Nothing more need be done. If it is not so, then you decide what are the reliefs that you get, because there was no NOC and there was no full payment. So there may be damages, there may be damages for loss of business, there may be damages for various things. And that again would require then further evidence. So there is no need to record all the evidence at one time. You may have to cut off or rather dissect that arbitration, which remains anomalous quite often. Now under section 31, we go to subsection 7 for interest. There is an anomaly. One is interest as deemed reasonable by the arbitrator. Now the arbitrator will have to see the conduct of the parties, the time taken, the delays if any caused, applications made, how much of cost could have been incurred or not been incurred, and determine that the period that has been lost should be compensated by way of a particular percentage of interest. If not, the Act says that it would be 2% higher than the current rate. Now, current rate of what has not been specified in the Act, except that it would be as per Section 2 of the Interest Act. Now, in the Interest Act provision for interest is not what the banks charge when they give out loans to parties. Those interests are much higher. They become actually in practice the commercial rate. Because the banks charge, the other parties also charge. So between the parties, they may agree to a far higher rate of interest than what could be given under the Interest Act. Under the Interest Act, the interest that the banks charge on FDRs could be considered. And that interest is far below, sometimes not even half of what the banks themselves charge for loan. So under the statute itself, this remains an anomalous position, and much depends on what the arbitrator considers a reasonable rate of interest, depending upon the facts of the case and the conduct of the parties. Okay. Then comes section 31A. 31A2 is for costs. Costs, of course, generally it goes, as the Arbitration Act says, the successful party gets from the unsuccessful party. But sometimes there could be a different order. And that is left very wide so that the arbitrators would decide on whether to grant costs or how much costs to grant. And that would be by reasons. This is the culmination of the award, of the entire arbitration, by an award, I would say. Section 33 deals with corrections. Quite often, there are many arithmetical corrections that are left out. There are some kinds of things which are left out where the parties would say that please consider this aspect also. It has been left out. They may file a section 34 application to challenge the award on that ground. And the court may also say that a particular aspect is left out. Go back to the arbitrator and have it corrected. So the award plus something else, or the award nothing else plus. That also could be done. But that is only for correction and not for amendment of any award, of course. It is just like a judgment. The arbitrator becomes non-est and cannot thereafter amend the award. Once that is done, you go to section 34, which is not in the realm of arbitration actually, but the challenge, I may only say that the challenge is essentially on grounds of public policy. Public policy is for two aspects. One is fraud or corruption, and one is patent illegality. We have come to know of the latest decision in the curative petition of the Supreme Court by the Chief Justice of India, where the arbitral award has been set aside on the ground of patent illegality. And we will have to now see how that judgment is used or perhaps even abused by parties. Because to challenge the award on the ground of patent illegality at a very late stage, when considering that some of the aspects were not considered, is what courts will have to now determine. And the obligations of the arbitrators as laid down in the judgment would have to be followed. But that is, of course, not an anomaly. That is how we move from precedent to precedent. Now comes section 35, finality. Subject to this challenge, which must be under this 4-month period, 3 months plus 30 days, that is no more, no less, the award becomes final. Then that award has to be enforced. So when you go for enforcement, it is as per the money decree. And money decree would mean that there would be no stay in the first appeal under the CPC under Order 41. So under 41 Rule 5, you can get a stay only upon deposit of some amount. Since the award, which is usually a money decree or taken to be a money decree, is of some arithmetical figure, the stay application would also be required to be filed, and there won't be an ipso facto stay. Except, of course, and as in the 2019 Act, where it is vitiated by fraud or corruption, where there could be a stay of the award. Then comes appeals. The provision for appeals must be read with section 5, minimal court interference. So unlike what in the suits we have all sorts of revision applications for every single stage of the suit, it's not so for arbitrations because there is minimal interference. Now, when will there be interference? Sections 8, reference, Section 9, interim relief, Section 17, also interim relief, Section 16, jurisdiction, and Section 34, which is considering the entire award. There would be appeals from there. So we read Section 37 and 5 together. Then comes the question of deposits. It should have been earlier, but it is later, much after the award section. Nevertheless, during the award, the arbitrator can call for certain deposits. As I interpret it, if once you charge ad valorem fees, there is no question of depositing anything else. There is no question of charging anything else. You have to charge that, not a penny more, not a penny less. But it is interpreted differently, and some other charges could be claimed in certain other applications. Now, these deposits will be made by both of them, both the parties equally. If there are 7 parties also, equally. If one party does not deposit, the other party may say, it is not in my interest that he does not deposit and you don't go on with the arbitration. Never mind, I will deposit his amount, his fee also. So that deposits can be taken. That is under section 38. If both of them don't deposit, the arbitrator may terminate the arbitration or suspend the arbitration until it is deposited. If they refuse, there is no question of suspension, there would be termination. But this payment by one is a little anomalous because the law says if the party fails to deposit. Now a party may say, yes, 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 I will deposit, give me time, I will deposit, I don't have money, give me time, and ultimately don't deposit. It is failure. Another party may say, no, this is a very exorbitant claim, I will not pay for it. So he refuses to deposit. Now the legislation does not say if he fails or refuses to deposit. The legislation only says fail. What is that anomaly and how can it be sort of reconciled? If you refuse also, you are failing to deposit. So even upon refusal, if one party refuses for whatever reason, that I don't have the money, he can refuse, the other party will say, all right, I am claiming the money, I will pay, fine. If one party says, I will pay but not pay, fails to deposit, fine. In both of these cases, the ultimate result would be the same and should be the same, that one party may pay, and if they don't pay, then you go to the next section, section 39. The arbitrator will say, well, I've done my job. I'm not going to give you the award. I have a lien on the award. Once again, therefore, then the court interference would be there, and the court will see whether the amount will be paid or not at a stretch, or whether it can be deposited and paid for the arbitrator, and then the arbitrator could give the award and then take it back. Okay. So these are various matters where facts of the case would be different and the ultimate orders would be different. Then we go, friends. Now, this is so far as the entire domestic arbitration is concerned, which Justice Dhanuka dealt with as per prose and which I dealt with as per practice. But we have to go to the schedules. And the schedules will have to be read along with the Act to remove all kinds of anomalies which actually prevail in practice. Fourth schedule I have already dealt with. It is ad valorem arbitration fee, which can be charged. Now, there is some kind of a notion that if 100 rupees are payable, you pay the sole arbitrator 100 rupees plus 25% as per the fourth schedule, 125 rupees. If you have 3 arbitrators, do you pay 100 plus 100 plus 100? Or do you pay 33 plus 33 plus 33 to make it 100? You may have 10 arbitrators, you may have 100 arbitrators. It is of no concern to the arbitrators. If you just want to have more, you means the parties. And therefore, as we can read the law, it is that you have to pay 100 plus 100 plus 100 and not that 25. Because otherwise, that provision with regards to that additional 25% has no meaning. The sole arbitrator will get 25% more than the panel arbitrators, because panel arbitrators may share the work, may discuss the work, and therefore may be in a better position to deal with it sort of quickly, expeditiously, and even easily, not the sole arbitrator. That is one aspect. The second is, as we already said, we have to read it along with 29A, and therefore if an amount is payable to a party, let us say under a document, if you are entitled to get 100 rupees, you are entitled to get within a reasonable time. And if you don't get it, you can charge interest. There is no provision for interest for arbitrator's fee. Therefore, it must be within the reasonable time. And what is the reasonable time? It is laid down in the statute. The statute says 12 months is the reasonable time. Earlier, the statute said from the time of reference. Now, after the amendment of 29, it says after all the pleadings are filed. And the pleadings must be filed within 6 months. So you can say after 18 months. Okay. So 18 months is a reasonable period of time to get the reasonable amount which is specified in the fortune. And as per my calculation, I think it is sufficient and it is fine if parties really finish off the dispute within this 12-month period. As Mahatma Gandhi said, there is enough for our need, but not for our greed. But if this is not finished within that time, then as I told you have to see the conduct of the parties vis-a-vis the conduct of the arbitrator, and the arbitrator may say that now this is it. So now it is a fresh contract, and I will not act further unless I'm paid more. Or the court may say that you have to pay the arbitrator more, and if the arbitrator has delayed, the court may better say that this arbitrator will get less. That is what the legislation says. And that is the whip that I called right in the beginning, not only the stick with the carrot, but the whip. Now comes the fifth schedule. Fifth schedule doesn't pose much difficulty or anomaly. It is the disclosure of relationship. I don't think there are any parties that I know of have said that, you've got some kind of a relationship and yet you've taken up arbitration. We never do that. In fact, for the slightest of reasons, even for holding shares or so, we have refused. So that doesn't come much into play, but the sixth schedule is very important. The sixth schedule is disclosure of time. And when the court appoints, maybe when the parties appoint, it is not so. But when the court appoints, the court calls upon the arbitrators to say, do you have enough time? Will you be in a position to finish this up within 12 months? And the arbitrator says yes and accepts the reference. Now, this is a solemn undertaking. It is a solemn duty. This disclosure of time under the sixth schedule must be read along with section 12(1)(b) of the Act. And 12(1)(b), as well as, of course, under 11(14) of the Act, the period that the arbitrator must take must then be for a reasonable amount of time. This is the real spirit of the Act. And why are there so many amendments? Because arbitrations were not done within that period. And therefore, to complete the arbitration within the specified period is the bounden duty of the arbitrator. And if the arbitrator feels that I've got enough now on my hands, it is for the arbitrator to say, no, sorry, thank you, I don't want it. But the arbitrator cannot keep taking and not deliver. Okay. So this, I would say, is an anomalous position, but it must be settled with some pangs of conscience. The seventh schedule again is relating to relationship and doesn't bother us much. The eighth schedule was incorporated in 2019 Act. It lays down the qualifications and experience of an arbitrator. Now, please consider how that becomes important. It has not yet come into effect. But earlier, arbitrators were either complete strangers to law. They may be accountants, architects, there may be family persons who would be appointed arbitrators. There have been family persons who have not known the law and not decided as per the law, and those awards have been set aside. But there are several awards which have been completely enforced of those kind of arbitrators also. Now we have a culture of having arbitrators who are not only, say, persons of law, who are lawyers, who are judges, who are retired judges, not of course sitting judges, but even young lawyers. Now this award, there is no first appeal. There is nobody who is going to accept that we will see it again. There is only a challenge to the award. There is only setting aside of the award on certain grounds, which I told you: fraud, corruption, patent illegality, essentially. Otherwise, of course, incapacity to act and all, we don't want to deal with. It doesn't come into play much. So, should we not have the qualifications of an arbitrator, which could at least be qualifications of a judge? Say 7 years for district level, 10 years for high court level, and further. But this good provision has not come into being. arbitral tribunal who had to be the arbitral council who had to be appointed and who had to do n number of things, including having seminars, webinars with stakeholders to actually have a whole arbitration culture, has not been brought into effect. The only thing which has been brought into effect has whittled down the amendments of 2015. And all right, we accept that, especially for the section 2324, where the period has been extended. Now, these various things pose certain kinds of anomalies and difficulties, and the sooner we get judgments of the High Court, the better. And once that is done, Justice Dhanuka's overview would be prevailing. So this is only a sequitur to what he says, but I would end with a short couplet. Each morning see some work begun, each evening see it close. Something attempted, something done has earned a nice repose. If we have that work culture, we would then be a real hub of arbitration that we now hope to be or claim to be, but we are not. Thank you.
Thank you, ma'am. As usual, the session was quite insightful. And I think there are a lot of brownie points for everyone who listens it or listens it subsequently. And we hope that whatever rays you have shown, they will be taken up and it makes the brighter sunshine in the Arbitration Act. Thank you, everyone. Stay safe, stay blessed. Namaskar.